Hello and a very warm welcome to World This Week by Latest Laws. This is our weekly program, so subscribe and press the bell icon to get notified. My name is Monica Rahar and let's get started by having a look at Supreme Court this week. On Friday, the Apex Court set a 5-day deadline for the states to furnish details of norms which are employed for releasing prisoners accused of minor offences from overcrowded jails in accordance with the Top Court's last year's order, which is dated March 23. The Top Court, by virtue of this order, intended to prevent spread of COVID-19, but found this order to be very poorly implemented. A 3-judge bench, which is led by the Chief Justice of India, frowned upon the rather relaxed and the delayed approach of the state authorities in releasing the inmates who are facing trial or who are convicted in offences which are punishable with less than 7 years of imprisonment, leading to hundreds of prisoners over the age of 60 years still being confined to prisons even after more than a year of this order has passed. Now here we need to understand that the top court took so motu cognizance of this delay which is shown on part of the authorities to release people from jail even after getting bail from courts. Former Union Minister Arun Shourie, he has knocked the doors of the top court challenging the constitutional validity of Section 124 A of the Indian Penal Code. This section defines the Sedition Law for India. Arun Shourie, in his plea filed before the top court, sought appropriate directions from the Apex Court, declaring Section 124A of the IPC as unconstitutional and said that it is violative of Articles 14 and 19(1)A of the Indian Constitution. On Wednesday, the Apex Court took so motu cognizance of the decision of UP Govt to allow Kanwar Yatra amid COVID-19. On Wednesday, the top court said that messages which are exchanged on social media platforms like WhatsApp, they cannot be used as evidence. It also ruled that the author of such WhatsApp messages cannot be tied to them, especially in business partnerships which are administered by agreements. A top court bench of the Chief Justice N.V. Ramana and Justice A.S. Bonappa and Justice Hrishikesh Roy questioned the evidentiary value of WhatsApp messages by stating, and I quote, "Anything can be created and deleted on social media these days. We don't attach any value to the WhatsApp messages," unquote. On Thursday, the Apex Court reserved the verdict on a plea which is filed by the Kerala Govt seeking direction to withdraw cases against prominent CPIM leaders for alleged vandalism in the Kerala Assembly in 2015 when the current ruling party in the state was in opposition. On Wednesday, the Supreme Court held by 2:1 majority that the minimum age limit of 50 years, which is prescribed by the Tribunal Reforms Ordinance of 2021 for appointment as members in various tribunals, to be arbitrary and discriminatory. Now let's proceed to the next segment of our news analysis and have a look at the Delhi High Court this week. So on Thursday, the High Court of Delhi granted more time to the Government of India and others on a plea challenging the report of a fact-finding committee constituted by the Delhi Minorities Commission in relation to the February 2020 Northeast Delhi violence case. The Delhi High Court has directed the CBSE to decide within a period of 8 weeks if it would refund the examination fee taken by students or taken from students of class 10th or 12th board examinations, as the same have been cancelled due to the outbreak of COVID-19. On Friday, the Delhi High Court sought the centre's response on a plea by New Zealand origin YouTuber Karl Rock's wife against the blacklisting and cancellation of her husband's Indian visa. Justice Rekha Palli pointed out that there should be justifiable reasons for the blacklisting, which should have been communicated either to the YouTuber himself or the petitioner, who is his wife. The High Court posted the case for further hearing on September 23. On Friday, a division bench at the High Court of Delhi said that if COVID vaccines are administered to children without proper research, then it may be a disaster, while objecting to the submission of the petitioner seeking research on vaccines for children in a time-bound manner. A division bench of the High Court, consisting of Chief Justice D.N. Patel and Justice Jyoti Singh, stated, and I quote, "It would be a disaster if vaccines are administered on children without proper research," unquote. On 14th of July, a division bench of the Delhi High Court said that the requests for proposal or tender issued by the Airport Authority of India for engaging agencies to provide ground handling services at Group C and D airports, it is discriminatory and arbitrary and is required to be struck down. The court further found that the tenders or the request for proposals in question in respect of Group D1 airports having been found to be offensive, the entire tender would fall on the ground, as the offensive part cannot be severed or separated for the purpose of saving the rest of the tender. On Tuesday, the High Court of Delhi asked the centre to share in a sealed cover its office memorandum pertaining to the deportation of illegal migrants from Bangladesh. A single judge bench of the High Court has held that an attempt to re-agitate issues which had already been decided in the judgment under review cannot be permitted. It further stated that a review petition cannot be treated as a second opportunity to argue the matter which has already been adjudicated. Now let's head to the next segment, which is of Bombay High Court. So on Friday, the Maharashtra government opposed before the Bombay High Court a bail petition filed by activist Sudha Bhardwaj, saying that her contention about a lower court lacking jurisdiction, it was incorrect. Sudha Bhardwaj, who is in jail since September of 2018, has sought bail on the technical ground that the court which took cognizance of the charge sheet initially lacked the power to do so. On Wednesday, the Bombay High Court observed orally that the system is paralyzed due to the COVID-19 crisis with restrictions and limited number of days, and the court also showed deep concern on the number of under-trial prisoners who are languishing behind bars for so long. Now let's proceed to the next segment of our news analysis, which is the Madras High Court. So on Friday, the Madras High Court made a historic observation with respect to the right to be forgotten. The right to be forgotten, it refers to the right to have one's own personal details removed from the public domain, including from the internet, once such information is no longer relevant or required to be publicly available. The single judge bench of Justice N. Anand Venkatesh stated that an accused person who is eventually acquitted of all charges would be entitled to have his name removed or withdrawn from court orders pertaining to the crime he was earlier accused of, in protection of his right to privacy. The High Court, in another matter, has observed that the State Transport Commissioner was obligated to ensure strict compliance of the motor vehicle rules, which require all two-wheelers to be fitted with rear-view mirrors while being driven on the roads. Now let's proceed and have an understanding of an update coming from the Punjab and Haryana High Court. On Friday, a judge of the Punjab and Haryana High Court recused himself from hearing a public interest litigation which alleged that Punjab Cabinet Minister Rana Gurmeet Singh Sodhi, he perpetrated a fraud on the state funds by taking compensation twice. That is, first in the year 1962, followed by the compensation which was taken for the second time in the year 2012 for acquisition of the same piece of land. The petition has sought directions for a CBI probe into the matter. Now let's proceed with the miscellaneous segment of our news analysis. So, on Wednesday, Union Ministry of Home Affairs directed the states and the Union Territories to immediately withdraw cases which were booked under the now repealed Section 66A of the Information Technology Act of 2000. A Gurugram court has dismissed bail appeal of Ram Bhakt Gopal Sharma, who is also known as Ram Bhakt Gopal. He was arrested for delivering an inciting speech during a Mahapanchayat in Pataudi. He also brandished a gun and opened fire in Delhi's Jamia area in January of 2020. The judicial magistrate of Pataudi, he said that the consequence of these kind of activities, it may be very far-reaching and more dangerous, and it may lead to and translate into communal violence. On Wednesday, Guwahati High Court agreed to hear the National Investigating Agency's appeal challenging a lower court's verdict that discharged MLA Akhil Gogoi of all charges, including that of sedition, in relation to anti-CA protest case. On Thursday, a Delhi court said that it will hear on July 27 the bail plea of former JNU student leader Umar Khalid. He was arrested under the stringent Unlawful Activities Prevention Act in relation to the Northeast Delhi riots conspiracy case. On Thursday, the government of Delhi said that Lieutenant Governor Anil Bajal has rejected the panel of lawyers constituted by it to appear in trials of the cases linked to the farmers' protest. According to the Chief Minister's office, the Lieutenant Governor has asked the Delhi government to give Cabinet's approval on a panel of lawyers suggested by the Delhi police. Now let's proceed with the last segment of our news analysis, which is the international news. On Tuesday, Nepali Congress President Sher Bahadur Deoba, he took oath as the new Prime Minister of Nepal. This development has come a day after the top court of Nepal, which is the Supreme Court, overturned Prime Minister KP Ohly's 21st May decision to dissolve the House of Representatives. On Sunday, the High Court of Justice of Israel, it ruled that all legislations denying surrogacy rights to same-sex couples and to single men, they will be null and void 6 months from the date of decision. On Sunday itself, Israel's High Court of Justice accepted an appeal by the Movement for Freedom of Information NGO, ruling that Prime Minister's office must supply 220 expenditure invoices from the Prime Minister's residence from 2015, which opposition leader Benjamin Netanyahu had previously refused to release on privacy grounds, overturning a previous district court ruling and ending a 6-year-long legal saga. That's all we have for this week. Thank you for being with us, and in case you need more updates or information with respect to any of these news events, kindly head to the description section.